Good morning and welcome to the 11th episode of Coffee with Casey. I'm Casey Hicks, a shareholder and the Chicago office managing attorney here at Weltman. This morning, I'm enjoying a nice cup of caramel cold brew in my nice mug since it's quite hot and humid out today. So good morning to everyone. I hope you are also all enjoying a nice cup of coffee this morning. Feel free to share what you're drinking in the chat. Today, my guest is Matt Pomy out of Weltman's Pittsburgh office. Matt represents financial institutions, small business creditors, mortgage holders, and works directly with in-house litigation specialists. Matt also holds a spot on the 2025 Pennsylvania Super Lawyer Rising Stars list. Congratulations, Matt. Thank you for being my guest today. And what are you drinking this morning?
Thanks, Casey. I'm drinking Diet Coke. I'm not much of a coffee person. My preferred caffeine delivery system is usually soda. So I've got a nice cold Diet
Love
Coke
it.
this morning.
All right. Well, cheers. All right. As a reminder, everyone, this is an interactive session. So please submit any questions that you have throughout the presentation through the question button on the control panel. We'll try to answer as many questions as we can. Any questions that we don't get to end today's webinar, we will reach out afterwards to make sure all your questions are answered. Also, another reminder, this webinar is being recorded, and at the conclusion of today's session, a link to the recording will be sent to all attendees. And also, there will be a short survey, which we would appreciate any feedback that you have regarding today's webinar. Any suggestions you have for future topics is also appreciated. And with that, we'll go ahead and get started. So we're looking forward to talking to you guys today about today's key topics. And those are, let me get to the slide, recovering collateral post-death when the estate or the heir retains possession, a practical guide for creditors, what happens to collateral when a borrower dies, why probate changes the game, and the unique challenge of third parties in possession. So with that, Matt, I'll kick it over to you to get us started.
Absolutely. Thanks, Casey. So yeah, the thing I always like to talk about first is the human aspect of probate collections. It's not something that I see often dwelled on in the normal collections world, but I think empathy is really important when you're collecting on deceased accounts. And that's because when you're working these sorts of files, you're often dealing with someone who's just recently lost a loved one, and may not be too familiar with even that process of going through the probate, much less going through some sort of disputed collection matter. So I always like to highlight empathy first, and then coming through with with our expertise on the actual law and the actual issues. So start with empathy, follow up with clarity. You're dealing with people who are likely going to be upset. They're not going to be fully understanding of the process. And it's our job, in a sense, to kind of walk them through and establish that rapport and that level of expertise with whoever is managing the affairs, and kind of go forward from there and set the right tone for the proceeding, because it's not likely to be a contentious, heavily litigated matter. You want it to be more cordial, and you want it to be, as the statute sets it up, as the estate kind of working for everyone. And if you come in guns blazing and you're not considerate of what the people might be going through, you might set yourself up on a difficult path to kind of make that a beneficial interaction for everybody. So that's the first thing that I always like to talk about. And then from there, there are a handful of scenarios in this sort of third-party possession space that you'll come across in probate. Number one is the thing I see most often is vehicles driven by the heirs. So you've got the mother or the grandmother, whoever passes away, she's got an old car that she's been driving for forever, and leaves it to grandson who just turned 16 or something like that, and thinks, oh, well, we'll just keep paying the loan and it doesn't matter from there. But you've got to think, is that car still insured? Do we know where it is? Who's got the keys? Because you never know when those payments are going to stop. And it's hard to take the word of heirs while they're still in contact, because they could just disappear off the face of the earth right away whenever they feel like it, and then you're stuck.
Matt, what suggestions do you have to try to get proof of insurance from heirs?
Yeah, so I'll go back to early communication is going to be really important. If you know that situation is happening and you are able to plan for it, you can have sort of check-ins to make sure that insurance is still maintained, through that communication. And once you get into a probate contest, especially, the court's going to want to make sure that the estate assets are protected. So you're going to have a little bit of backup there if you're getting some pushback on that issue.
Okay.
So the next thing is business equipment is not as common, but if there is a family business and maybe the primary borrower is the one who passed away, but the business is still continuing. So then you have a situation where maybe you've got balers for a farming equipment or something like that you're secured on, and your primary borrower passes away. The farm is still active, still making those payments. So you're not really sure exactly where the obligation lies at that point if you don't have that secured against the actual business. Another one, occupied homes. That can really get complicated, as I'm sure you're aware, Casey.
Yes.
I'm sure you've got horror stories of trying to evict holdovers there, but in probate, in the probate space especially, we see it like with a borrower who passes away, and the heirs may or may not try to maintain the mortgages. And kind of go from there. For that, you really want to understand where you are in the priority structure, where your mortgage is, or is it a second mortgage, is it HELOC, is it a secured solar panel liens, is it fixtures on the real estate? Septic systems get really complicated depending on your jurisdiction, because sometimes they hold over, sometimes they won't. So you're really going to want to get involved early on in these kinds of scenarios to make sure you understand how everything was set up prior to the borrower passing away, so you know the best next steps going forward from there. And then other personal property just gets complicated, partially because of the increase in value, and also because it's hard to locate a boat sometimes.
Yes, yes, exactly.
Yeah, and RVs are usually not parked in people's primary driveway. So anytime there's any kind of storage component to a piece of collateral, you're going to want to make sure you identify where those things are if they're going to stay out there with these third parties. And I'll run back to storage just real quick. With boats especially, I'm going through this right now. We just repossessed a yacht. I think it's out in South Carolina, and there was almost $17,000 in storage fees, and that was just for winterizing the boat last year.
Oh my gosh!
It can get absolutely crazy for boats. Just the things you have to do to keep them safe when they're out of the water. So you want to really be sure to keep up on that situation. So when it comes to actually getting into the collection aspect, we've if you've done the groundwork to get in touch with the heirs who are going to be making the decisions, if you've gone through the state of what your collateral is prior to the passing, so you know where you're headed, the next kind of dividing line is whether or not there's going to be a probate estate or not. So whenever there's going to be an estate opened, you're going to want to have that information on the decedent at the ready, so you can start to build a picture of what their financial situation was at the time of their passing, because that's going to set you up to better know what is going to be obligated for that estate to do going forward.
And is the estate usually opened in the county where the person lived?
Yeah, so it's usually where the person resided at the time of their death. There are some situations where there'll be what's called an ancillary estate. So if there's a piece of property outside of the jurisdiction where the person lived, say they had, a second home in Florida or something, and they primarily lived in Ohio, they'd likely probate an estate in Ohio in the county where they resided, but they'd also be filing an ancillary estate in Florida to capture that other property.
Okay.
And that can get complicated too, because then you're working with two separate deadlines. So then if you're a creditor of the Florida property, if you have that second mortgage on the Florida property, you're going to be bound by those Florida deadlines in the Florida estate. But if you're in Ohio, you're obviously going to be in the Ohio estate. So yeah, but and that kind of makes it complicated going back to you don't always know where everything is. So if you do have early contact with the decision makers, that can be helpful to know, is the estate planning an ancillary estate? Are we able to kind of adjust our plans accordingly to go forward from there?
My name is Stone.
So yeah, if there's no estate.
Oh, sorry, Matt. One other question going back to storage. Can any charges incurred for storage be added back into the loan if the creditor pays for the storage of, say, that $17,000 for that yacht that you got?
Yeah, so that we included all of that in our deficiency balance.
Okay.
Yeah, so as long as you follow the proper notice requirements, and you follow all of that sort of thing, like as you usually would in a living account, there's no reason why you wouldn't be able to roll those costs in. But especially when the numbers start getting big, you're going to really want the backup for that cost.
Like the receipt or proof of payment or, okay.
Right. And even if you have an invoice from the storage facility or the auction house, would be even better, because you got to remember the courts are there to protect the estate and the beneficiaries. So if we're saying that our costs are X and we're depleting the estate by that amount based on those costs, you're going to want to make sure that you're able to justify that and have those backups ready to show that that was an actual cost incurred. And needs to be reimbursed. Absolutely.
Okay.
So I'm just gonna send it to you.
The real complicated factor is if there's no estate, that kind of limits options for creditors, but it does kind of streamline the process in a lot of ways. If you don't have an estate, if you don't have any indication from heirs that anything's going to be happening to kind of roll those assets, or if there aren't any assets to go through a probate other than the secured collateral, it's time to start looking for repossession options. Because if there's not going to be any money coming through a probate, it's time to start getting that collateral and recovering what we can as soon as we can. So if there's no estate and you don't have any assurances of being, addressed by the family members, you go through, your typical repossession processes and start getting that collateral secured, because all collateral is going to depreciate. Cars, especially if equipment's being used, you never know if it's going to break. The risk of loss is directly on the lender in these situations, especially when there's not going to be a probate with any money coming in. So yeah, when there is a probate, you're going to want to file a secured claim. That is a piece of advice I give all the time. I will always advise to file a timely claim. Just because you have a lien, just because you have, this or that, I don't think that's necessarily enough to feel comfortable with going forward in all situations.
And
so I always,
the timeliness of those claims, that's going to be state specific, right?
Oh, for sure. Yeah.
Okay.
And it's going to vary sometimes within the state depending on how you get notice of it, which is kind of an extra wrinkle for probate matters. So it's in some situations they can just give you notice by putting an ad in the paper. In some states they got to send you specific notice advising you of an estate being opened. In some they don't have to give you any notice. We'll talk about it later. But in Ohio, the deadline on claims is set from the date of death, regardless of whether or not the creditor knows about it. So the only main wrinkle there is for mortgages. Typically, claims that are secured by real estate aren't subject to those typical deadlines, and that gets into, mortgages are publicly recorded. The public policy of not needing those to comply with the deadlines is pretty clear there. But yeah, even still, always file a claim. You can file it as a secured claim, which is a slightly different process than your typical unsecured claims, because similar to bankruptcy, probate estates pay out creditors based on what kind of debt they are. So if you're a secured claim, you're going to get paid before unsecured claims. So I think it goes administrative claims, secured claims, and then unsecured claims in most jurisdictions. So you want to make sure that you would alert everyone that you have secured collateral and you're paid before anyone else. Another different kind of claim that's not as common is you can file a contingent or an unliquidated claim. Excuse me. A contingent claim is for when the right to payment is not absolute. It's still waiting on something else to happen. A common instance of that is guarantor liability. So if you have a loan to a business and you have a personal guarantee from the business owner and that guarantor passes away, the right to payment isn't absolute in most situations unless you have death as a default and things like that. But it's still waiting on the business to default on the loan for that guarantor to be liable. So in probate, they allow for that. You can go through the process to file a contingent claim, letting the court know that, hey, look, we have this claim if this other thing happens, and you get into a different sort of deadline track there. So you have more time to address the claim in that way. Similar with unliquidated claims, it's when the right to payment is absolute, but the actual amount that's going to eventually be owed isn't known quite yet. My usual analogy for that is if we've repossessed a vehicle and that's waiting to be sold. The total claim would be the amount of the loan on the vehicle, but then what's actually going to be owed is going to be what's left after the vehicle is sold. So you could file an unliquidated claim to still maintain in that deadline period, but still preserve the right to amend later once that claim becomes final, basically. But through all this, communicating with the executor is going to be really important. And it depends on how they react to how we're going to move forward. When there's a cooperative estates, it's pretty easy. You make a call, you talk to the executor, you say, yeah, cousin Jimmy's got the car, we'll get it paid off, give us a payoff, we'll get it done. That's cut and dry. It gets a little more complicated when they start trying to assume loans. Car loans, solar panel loans is a common one. Refinancing mortgages is less common, but still effective, I guess. But that brings into the question of whether or not the people who are going to be assuming those obligations are actually creditworthy to do that. So you're going to want to make sure that you go through that process with them and make sure that you want to be doing business with that person who wants to take over this And you want to do all of these with formal agreements. You don't want to just wink at any kind of changing of hands in a probate context, because you never know when that's going to come back. And really what we want is to minimize the time we are involved with the probate, because the more time we have to spend in the probate space, the more complicated it's going to get, and likely the more litigation is going to go forward. And unfortunately, estates are able to pay their attorney out of estate funds. So the more time we spend in the case, the more the estate attorney is billing, and the less the assets are there for creditors. So we really try to go as quickly as possible.
Yeah.
Sometimes we can't.
Yeah.
Sometimes estates are just ignoring creditors, or they're not being necessarily cooperative. They're trying to whittle down the bill. They're not being reasonable in terms of timelines or anything like that. And then it's time to start thinking about how to force the issue, either in probate or out of probate. Going out and recovering the collateral is absolutely a way to get the get the estate to act. They'll still have the redemption period and everything like that, but it's a good way to get their attention. And then you kind of can try to go from there. You can also get involved in probate motions practice. If the estate's dragging their feet and they're not really doing too much, you can go into court and let the judge know, hey, judge, we've been sitting here for 2 years. We've got a piece of property that we have a second mortgage on. There looks to be equity in the real estate, but the executor's not doing anything. What can we do here? And basically try to get someone else in who's going to follow the law and get creditors what they're due. Because in a sense, the states should be working for creditors as well. So going back to no estates, that can again get messy. We talked a little bit about replevins. You can go repossess the vehicle, repossess the equipment, whatever's out there. If you want to. I know most solar lenders aren't looking to go take panels back off the roof. But yeah, but that's a determination you can make in the moment. One thing I do want to mention here is forcing estates open. Because of the tight deadlines, specifically in Ohio, there's a process where if an estate is essentially buying time until there's no possible way to file a claim against an estate, there's a process where you can force an estate open as a creditor and present the claim in a timely manner, and then allow the family or the heirs to step in after, and then you have a timely filed claim. The biggest thing with that is it is a complicated process, and it does run the risk of potentially needing to stay in and administer the estate in full, which is sometimes a complicated thing for a creditor to do.
Right. We did have another question come in, sorry, Matt, about filing probate claims. Does a probate claim have to be filed by an attorney, or can it be filed by the creditor themselves?
I think that would probably be jurisdiction specific.
Okay.
I know we file a lot of claims as authorized agents in Ohio, but I know we have to have a South Carolina attorney file all of our claims in South Carolina,
Okay.
and I think Kentucky as well, but I may be switching those up.
But depends on the state.
Yeah, it depends on the state. You want to make sure if you're able to sign as an authorized agent, that's likely something that can work. But some states do want an attorney to sign on behalf of a corporation.
Okay.
Yeah. So again, when you're looking at going repossessing collateral, You're going to want to be mindful of your particular state's rules and limits. Where can you use peaceful recovery means, and where the line is for breaching the peace and when you have to get a replevant action involved. Specifically, one thing comes to mind. We were looking for a camper in Oklahoma, I think, and it was behind a gated community, and they wouldn't let the repo guys into the community, and so we had to go in, file the replevant action, get the order, and then go out and get it. So you're going to want to know where you're going to need that sort of court action and start that as early as possible. So real estate is, again, like I said, a whole nother can of worms. If you have heirs that are staying in the real estate, in theory, they are interested parties, so they're going to be people you're going to have to deal with in a foreclosure action, not just from the standpoint of evicting them, but it also implicates some bankruptcy complications potentially. In one case that I had, we were trying to foreclose on some real estate where the decedent passed away, leaving their three adult children who all lived in the house. This was a credit union. All three of them were removed from the credit union's roles. The credit union didn't want them to continue in the house, and they showed no ability to actually make the mortgage payments. So they were trying to move forward with the foreclosure. One of the heirs files bankruptcy, and then throws everything
Right.
all into haywire, because we've got a bankruptcy matter now while the probate matter is still pending. He doesn't even own the house yet, and he filed the bankruptcy and mucked up all the works. So that's a real illustration of early intervention. Would have gone a long way there, I think.
Right.
Yeah, so I want to hit some important state-specific considerations that just jump out to us, jump out to me in our everyday practice. Like I said, Ohio is the strictest one. You got 6 months from the date of death, and they've got to be appointed as the fiduciary before you can present the claim. So that really tightens the window of when you can actually get get a claim out to the fiduciary. In Pennsylvania, it's almost the opposite problem. So in Pennsylvania, they notice creditors of what they want to pay everyone, and we have to object. If we don't, that's the order that the judge is going to sign, and it's going to be done. That's a whole separate issue. In Florida, there's a quick turnaround time. You've got 30 days to file a complaint against the estate. Once that's rejected, the Illinois rules are interesting. I know, Casey,
Yes.
you've interacted with those quite a bit. They can reject it and tell you to file a claim, and then we have to file a claim, and then it kind of starts the whole process over again. It's very strange.
It's like duplicative a little bit, yeah.
Yeah. So you just got to make sure that whatever hoops you have to jump through as a creditor in these different jurisdictions, you've just got to do it. I mean, you've got to have the deadlines laid out. You've got to keep, reminders in your internal file, because otherwise you're going to be barred. And once you're out of a deadline in probate, you're done.
And with that, Matt, we're coming very close to the end of our time. So I'm going to skip to the end because I wanted to ask you one final question about sending referrals over to Weltman. We got a couple questions about this throughout the webinar. So when a probate referral comes over to Weltman, could you just do like a quick little overview of what we do when we get one of those referrals?
Yeah, absolutely. So if you refer a claim to be filed with us, first thing we'll do, we'll start the probate search. We'll start sending location letters and making calls. So that goes into our skip process, trying to find who is the decision maker and start those conversations with them as soon as we can. trying to find if there's a probate action already pending. We got to get involved in that. Once we find the estate, or once we locate who is going to be responsible, then we either file a claim or start working with whoever's been responsible outside of an estate context to try to figure out what we want to do from there, if we're going to go try to repossess anything, or if we want to, or if we're able to make some sort of agreement at that point. And after a claim's filed, we pursue it until it's an allowed claim. As long as it's an allowed claim, the court's not going to let that estate close without addressing it. So, you know, we want to make sure we're involved as involved as we can, you know, balance dictating that, and make sure that we're paid in a timely fashion and the estate moves forward as it should.
Okay, great. Thank you, Matt. And with that, everyone, that concludes today's episode. Thank you so much for attending. I hope everyone found today's information beneficial. Let us know if you want to see a part 2. I know we didn't get to cover everything. And just a reminder, a recording of today's webinar with the PowerPoint will be sent out to all the attendees, and please fill out the survey. We appreciate your feedback. Thank you, Matt, and thank you everyone for attending. Have a great day.
Good one.